Intellectual property law firms versus patent filing services. Which one is better for innovators? Most inventors get this wrong by thinking filing a patent is just a formality, but the truth is that protecting your innovation requires careful strategy, and choosing between an IP law firm and a patent filing service can make all the difference. Intellectual property law firms offer comprehensive legal services, from conducting patent searches and drafting applications to enforcing your rights and handling disputes. For example, if you invent a new technology, an IP law firm can evaluate whether it's patentable, draft precise claims, and advise on international protection. They can also represent you if someone infringes on your patent, ensuring your innovation is legally defended. Patent filing services, in contrast, focus on the administrative side, preparing and submitting patent applications. They are typically faster and cheaper than full-service law firms, but do not provide strategic advice or legal representation. For a straightforward, low-risk invention, a filing service may be sufficient, but they cannot guide you through complex IP landscapes or disputes. So, which is better? IP law firms are ideal for valuable, complex, or internationally protected innovations where strategy, risk management, and enforcement matter. Patent filing services are suitable for simple inventions where cost efficiency is a priority. Many innovators start with a filing service for initial protection, then consult an IP law firm as their invention grows in value or enters new markets. The key takeaway is that protecting your ideas is not just about filing a document, it's about strategy, enforcement, and long-term security. Using the right professional ensures your innovation is fully safeguarded and maximizes its commercial potential. For inventors, the smartest approach often combines cost-effective filing with expert legal guidance.